Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm Hamlin Kerrigan. I've been practicing in New Hampshire for about 39 years and the Commonwealth of Massachusetts for about 30 years. I'm going to be talking about your obligations to your fellow business partners. So you have a business, it could be a sole partnership where you don't have a formal arrangement. It could be a legal entity called a limited liability company. It could be a corporation. So you're a partner, a member of an LLC, a limited liability company, or a shareholder of a corporation. In each of those situations, with these being closely held companies, not something that's publicly traded, you're not buying stock in AT&T or Microsoft. In that situation where you're working together in the company, you have obligations to each other. And you generally start off for all of those types of entities, you have a obligation of good faith and fair dealing with each other, utmost duty of good faith and fair dealing, you're fiduciary to each other. But that applies to both sides. Sometimes I've seen, and over the years, I heard that a minority shareholder says the majority shareholder has that obligation to them, but they don't feel the same way for their obligation to the majority shareholder. It's for both sides. Both have to treat each other fairly, and they also have to treat each other with a fiduciary obligation to share with them what's going on. What I see a lot of in my practice is outright theft. When that's a majority shareholder or the minority shareholder actually taking money from the company. This is not taking what they deserve from the company or making decisions and telling the minority shareholder perhaps that I'm taking a larger salary. I'm talking about just taking tranches of money from the company and putting it into that person's own private business entities that are not to the exclusion of a minority shareholder. They're just taking all the profit and then pulling it over when the agreements, either the shareholder agreement or the bylaws or the operating agreement in a limited liability company doesn't allow that. So basically, in these situations, shareholders can either have or partners can either have an agreement to themselves or they have a default provision in the statutes. Massachusetts and New Hampshire has for limited liability companies and corporations and partnerships. There's a default provision that if you don't have an agreement as to sharing of profits or sharing of losses or the fiduciary obligations, it's in the statute. So again, that's the floor, and then you can always change that. You can actually, by contract, remove some of your fiduciary obligations. I don't recommend it, but you can remove some of those obligations. Certainly in a situation where you're a majority shareholder, or maybe there's three of you, two of you might be able to make a decision as to the employment of the other, and you might by agreement agree that person is at will. All three of you are at will, and if two of you say one of you goes, you go. If they don't do that in these situations, closely held companies, your employment is an important part of the relationship. So if you're going to get rid of that person, there is fiduciary obligations. It's not like a normal situation where you hire somebody as a W-2 employee as the boss. In New Hampshire and Massachusetts, your employer will, other than some protected classes and protected activities, you can get rid of that person if you don't like their performance. If they're a shareholder or a member of a limited liability company, unless they have a clear agreement to the contrary, you generally have to sit down with them. I've had arbitrators in decisions say you should have sat down and had a beer with them or a cup of coffee with them and talk to them and tell them what's going on, why you're dissatisfied with their services, so that you actually treat them with directness so they have an opportunity to get better if you don't think that they're performing their job. So that's an obligation when you have an employee combination of, and most closely companies are, you're doing work in addition to, you're getting some compensation for your work in addition to whatever you share in the profits. In that situation, you have to actually talk to the employees. I've had in other situations, like I said before earlier, just outright theft. You need to know if you're a minority or majority shareholder or member of an LLC or partner in a regular general partnership. You need to know what the bank account says. You got to check the bank and see what's going on. See if there's something, see if the actual process checks match up with what's in the QuickBooks. If QuickBooks is your bookkeeping process, is it matching up? Is he or she, your fellow member, or partner or shareholder taking money out and just stealing from you. Because basically, if they're taking money and they're taking it and they're putting into their own business entities, and it's got nothing to do with your company, it's not benefiting your company, it's embezzlement. Just like the bookkeeper that's a W-2 employee that's taking money from them, it's embezzlement and it's theft. And you have to think about how big that issue is. If the majority shareholder is taking more money than you think they should be getting for a salary, well, that's a distinction between you and the majority shareholder, and it's going to be tough to deal with unless you can show that they're actually hiding it from you and they're taking tens and thousands, probably more like hundreds of thousands of dollars more than what they should be taking out of the company. Sometimes they're just bold and they just are taking the money and they're using it for their kids' education or the house on the lake, or again a business that's not related to this business. So they're maybe even usurping corporate opportunities where they're taking your business opportunities and they're diverting it to another company. All those situations, you have some rights, legal rights against that partner and maybe the company itself. I'm attorney Dan Meyer. I've dealt with these issues both in New Hampshire and Massachusetts for quite a few years, and I'm happy to talk to you about it. It's my telephone number is 603-883-5501, 603-883-5501, or you can check out our website, naturalllaw1.com. That's naturalllaw1word.com. Check out my personal bio. From there, you can look at the weekly vlogs I do on all of these topics. Thank you. Look forward to working with you. Opportunity rises. Thanks.